Sandra, now to Atlanta, where a motion hearing for Fulton County District Attorney Fani Willis is underway. A judge overseeing former President Trump's Georgia interference case will determine whether Willis and prosecutor Nathan Wade will testify on their alleged misconduct. Let's bring in Jonathan Turley, George Washington University law professor and a Fox News contributor. Immediately at issue, Jonathan, is when the relationship between Fani Willis and Nathan Wade began. They insist that it didn't start until after Wade was hired in 2022, but Wade's former divorce lawyer, who is also a colleague at his law firm, his name is Terrence Bradley, claims that the relationship began way back in 2021 before Fani Willis even became the Attorney General. That's a huge discrepancy.
It is, and this universe just gets stranger and stranger. Usually a former counsel, let alone a former partner, doesn't come forth with evidence suggesting that you have lied. But what makes this very serious is that these alleged false statements were put into an affidavit, and that affidavit was filed with other papers with the court. Keep in mind, Wade and Willis are prosecuting defendants in this case for making false statements and filing false papers or material with the court. So they are prosecuting people for exactly this type of allegation. Now, that's not the type of experience you're looking for in prosecutors. It's the type of thing that raises conflicts of interest. But if it is shown, and it's being suggested there are witnesses to this fact, that their relationship preceded the hiring of Nathan Wade, they're in serious difficulty. I mean, they are being accused of filing false statements with a court.
You wrote a lengthy column on this on your website, and you included a link to the affidavit that Nathan Wade filed with the court, which includes in part the statement, quote, "In 2022, District Attorney Willis and I developed a personal relationship in addition to our professional association and friendship." Again there, in 2022. But Ashley Merchant, who is the attorney for Michael Roman, who brought the challenge against Fani Willis, says since Willis and Wade were not forthright about their relationship in the first instance, there is no reason to believe that they are telling the truth now. If indeed they did not tell the truth in this sworn affidavit to the court, what are the implications?
Well, their position in this case has become untenable if this is proven to be true. Indeed, both of these attorneys could be looking at serious repercussions for filing a false statement of this kind. This was not some aside. This was the core of their argument. This is what they were flagging in the papers and raising with the court, that because the relationship started in 2022, there is less of a conflict of interest or other ethical problems associated with their relationship. If they misrepresented that date, then not only is their position as prosecutors in the case thrown into question, but their position as counsel, as attorneys, is thrown into question with courts. They could be referred to the bar for other possible action.
I want to ask you about Donald Trump's appearance in court, because apparently it just wrapped up there down in Fort Pierce, Florida. It's his first hearing in the classified documents case, in which the judge is asking for sort of defense theories of how they're going to approach the case. But I'm wondering, since the release of the Hur report, in which, and then we see the motorcade just leaving there in Fort Pierce, since the release of the Hur report, in which President Biden was let off the hook for willful retention of documents, which is the exact same thing that Donald Trump is facing 32 criminal counts on, does the whole kind of tone and tenor of this case change?
It has. It's changed legally and politically. It's hard to make the legal case of selective prosecution in most cases, but it is very hard to get away from the glaring contrast. Her report makes out a detailed case of willful retention of documents, of the disclosure of classified material to other persons, and the gross mishandling of documents. Those were all charged against Trump. And there is, I think, a legitimate question as to why that was the case. You know, the most that the White House and his counsel can say is that Donald Trump obstructed the efforts of the FBI. But there's an obstruction charge. That explains that charge. How about all those other charges? And that's the reason Hur had to get into the fact that the president would be a sympathetic defendant and has memory problems. It wasn't gratuitous. It was essential to try to explain why he's not charging the president or thinks the president should ultimately be charged after he leaves office.
Yeah. Biden, 0 counts of willful retention of the documents. Donald Trump, 32 counts. We'll see how this proceeds. Professor, good to catch up with you. Thank you so much.
So several of the motions to quash today are arguing that we shouldn't have a evidentiary hearing at all, and that quash is appropriate on those grounds. So to that end, in studying the law that's been filed up to this point, I think it's clear that disqualification can occur if evidence is produced demonstrating an actual conflict or the appearance of one. And the filings submitted on this issue so far have presented a conflict in the evidence that can't be resolved as a matter of law. Specifically looking at Defendant Roman's motion, it alleges a personal relationship that resulted in a financial benefit to the district attorney, and that is no longer a matter of complete speculation. The state has admitted a relationship existed, and so what remains to be proven is the existence and extent of any financial benefit, again, if there even was one. So, because I think it's possible that the facts alleged by the defendant could result in disqualification, I think an evidentiary hearing must occur to establish the record on those core allegations. So just to emphasize, I think the issues at point here are whether a relationship existed, whether that relationship was romantic or non-romantic in nature, when it formed, and whether it continues. And that's only relevant because it's in combination with the question of the existence and extent of any personal benefit conveyed as a result of the relationship. With that being said, I don't think that means that everything that has been raised in the defendant's motions, in Mr. Roman's or in the ones adopted by co-counsel, demand an evidentiary hearing. The testimony that would be produced at this hearing is not a deposition. It is still subject to the rules of evidence. And so I think the facts that are going to be developed on the record have to have some relevance and some materiality. Now, contradictions or how things play out could impact that, could change what is relevant. But at the outset, there are a few things that I don't think are. So to that end, I don't think the particulars of Mr. Wade's experience are relevant. I don't think those are material for an evidentiary hearing. His alleged lack of experience handling RICO cases or any inferences regarding the intent from that can be addressed at argument. But in my mind, as long as a lawyer has a heartbeat and a bar card, that lawyer's appointment standing alone is a matter within the district attorney's discretion. Similarly, I haven't found a reason to find that the regulations or the alleged violations of Fulton County Code are relevant in and of themselves. I think the violations of these rules can be argued as a matter of law if counsel wish to do that. But I've yet to see case law or anything indicating that these violations, if they did occur, are relevant to disqualification or a pending criminal case. And then finally, the motions have also evolved to include forensic misconduct on behalf of the district attorney. And again, I don't see how these are a necessary topic for an evidentiary hearing unless it's made an issue in some way. The public statements, in my mind, speak for themselves, and the application of the law to those statements can be argued, and I don't think any further testimony qualifying them is going to affect the analysis.
In the last few hours, lawyers for Fulton County District Attorney Fani Willis and Special Prosecutor Nathan Wade were in court trying to block subpoenas that would require them to testify at a hearing later this week.
Now, during that hearing, a judge will evaluate a motion seeking to disqualify the pair from prosecuting the ongoing Trump RICO case. Investigative reporter Zach Merchant has been tracking this story for weeks now. He joins us live in the studio with the latest. Zach.
Guys, the big takeaway today, despite DA Willis asking the judge to cancel that hearing, Judge Scott McAfee said it will proceed as scheduled. It's the latest development in the ongoing controversy in the case after one of Trump's co-defendants, Michael Roman, filed a motion seeking to kick Willis and Wade off of the case, accusing the pair of having an improper romantic relationship. Earlier this month, Willis and Wade admitted they had a relationship, but Willis denied benefiting from it. Willis asked the court to cancel the disqualification hearing and just rule on the motions, but today, Judge Scott McAfee said Thursday's hearing will happen.
The state has admitted a relationship existed, and so what remains to be proven is the existence and extent of any financial benefit, again, if there even was one.
Judge McAfee scheduled time on Thursday and Friday for the hearing and also left open the possibility it could last even longer. The judge did block the subpoena of Nathan Wade's bank records today, but so far he has not yet definitively ruled on whether Willis and Wade will have to testify.